Very good afternoon. This is Abhay from Manupatra. Thank you for joining us for this webinar today on the 5 essential legal requirements to form a contract. Our faculty today is Mr. Richard Brady, and he's going to talk to us from London. On behalf of Manupatra, I extend a warm welcome to Richard. Richard is a lawyer, an entrepreneur, financial advisor, and most importantly, a teacher. He's the head of the British Legal Center, where for the last 10 years, he and his team have been teaching law and practical legal skills to law professionals from Eastern Europe, Central Asia, Latin America, and Gulf countries. The session is approximately going to be of 30 minutes. At the end of the session, there's going to be an online test. The link to the test we have shared in the email invite. If you don't have it, don't worry. We'll share it again at the end of the seminar. For all those who score more than 60% in the online test, they'll get an online certificate with their marks mentioned. So without further ado, let me request Richard to share with us his insights on the topic. Sir.
Thank you very much, Abhay. Abhay, can you share the presenter's task with me? Because I need my screen.
So now you can share the presentation. I'll just make you the host.
All right, let me share the presentation. Good afternoon, everyone. Very nice to meet you all. I'm the host now. Abhay has sent me. Thank you very much, Abhay. Let me share my screen. As Abhay has told you, I'm the head of the British Legal Center, and we run training for lawyers and judiciary around the world. Mostly, we do this in Latin America and the Middle East, although we're now entering the Chinese and hopefully the Indian market as well. So I'm going to bring up a brief presentation on the essential requirements of contract. This comes from lesson 3 of our contract law course. The presentation will take about 20 to 30 minutes. As you have heard, there will be a question and answer session afterwards in that you will be asked questions, and I hope you will do very well to receive a certificate. Well, basically, why are contracts so important in our present world? Well, because they're the basis of civilized behavior. If I want something from you, I'm not going to hit you over the head and steal it. I'm going to make a contract to give you something in exchange for it. And if I don't, two participants have already raised their hand. Let me, I'll try and deal with questions as I go through, but we've got an awful lot of materials. Let me have a look to see what you, I have to let Abhay deal with questions. I will make this presentation available to Abhay so he can send it to you later, although if you want to take notes, that will be fine. Basically, we use contracts to civilize our behavior. If I want something from you, I'll enter into a contract with you. You'll get something from me, and I'll get something from you. If you don't perform the contract, then I won't go round to your house with a cricket bat. I will enforce it through the courts of law. Contracts are an essential element of civilized behavior in society. That is why they are so important. Now, what is a contract? Right. A contract is an agreement entered into voluntarily by two parties with the intention of creating a legal obligation. Contracts can be in the common law, in writing, or oral, or both partly oral and partly in writing. And contracts can be formed also purely from people's behavior. The courts will look at your behavior. If you behaved as if you've entered into a contract, regardless of what you were thinking, the court will assume you've entered into the contract and will treat you accordingly. Now, contracts, of course, have been around thousands of years. The earliest written code, the code of Hammurabi, the ancient king in Mesopotamia, had all sorts of written laws and terms of agreements. And by eventually the time it had come to the time of the Romans to dominate the world 2,000 years ago, they had worked out that it was so bad for people to enter into bargains and then break them that they would impose sanctions, fines, upon people who entered into contracts and broke them. The Romans gave us the Latin phrase pacta sunt servanda. This means a bargain must be kept. I cannot express it more clearly. If you enter into a contract, you must keep it. This gave us the modern idea that if you break a contract, you must pay, because flowing from this idea, people started to pay damages to the injured party when they broke a contract. So there are 5 essential requirements of a contract. Somebody must make an offer. The offer, in its exact terms, must be accepted by somebody else. The offeror makes the offer, the offeree accepts it. There must be something of commercial value passing between them. We call this consideration. 1 rupee has a commercial value, 1 rial, 1 dirham, 1 ruble, 1 pound. Consideration doesn't have to be equal to the value of what you get in return, but it must have a value itself. No matter how small, it must have an economic value. And next, the parties must have the legal and physical capacity to enter into a contract. In other words, you can't be a mental patient at a mental hospital or a child. And lastly, the parties must intend to create a contract, not some loose social arrangement to meet each other outside the cinema, but a business arrangement, which they intend to be bound by. We're going to look at all these 5 requirements in a little more detail in the next few minutes. Let's begin with offer and acceptance. First, somebody must make an offer. I will pay you $10,000 if you will build me a house. That's an offer. Then somebody must accept it. And they must accept it in the exact terms of the offer. They can't say, well, I'll build it for £10,500. That is a counteroffer. It kills off the original offer. Provided both parties understand what the offer and acceptance is at the time it's made, then this creates what's called a concurrence of wills, or another Latin phrase, consensus ad idem. This is important throughout all the common law world. These principles will apply not just to contracts in England or India or Australia or Ghana or Nigeria or Jamaica, but the entire common law world. Consensus ad idem was thought in the 19th century and 18th and early 20th century to be a reference to an exact point in time when both parties agreed. But in the late 20th century and in the 21st century, judges take it to mean both parties must know and understand what they are agreeing to. And by that, we call it a meeting of minds. Well, of course, that's a stupid expression, isn't it? How can the court know that your mind has met my mind? Said hello, shaken hands. Of course they can't know it. So the judges look to our behavior to see whether a reasonable person, reviewing what we did, what we said, how we behaved, would a reasonable person say that we had reached an understanding where we both knew and understood what we were agreeing to. Now, the offer. The offer can be to one person, can be to a group of people, or can be to the world at large, like a newspaper advert. I could put an advert on a telegraph pole advertising a reward for a lost dog. I'm making that offer to the whole world. You don't have to come up to me and say, Richard, I've seen your advert and I'm going to go and look for your dog. You don't have to do that to accept it. You accept it by your behavior. Now, during these times of the global pandemic, it's ironic that the leading case in the law of England and Wales and most common law jurisdictions as a precedent for this principle is the case of Carlisle and the Carbolic Smokeball Company, which was first reported, I think, about 1892, because it refers to a patent medicine which came into being because of the global pandemic of Russian or Asian flu, as it was known, in 1890. That Russian flu killed around 1 million people worldwide, as a result of which a lot of patent medicine companies sprang up. The carbolic smoke ball company was one. Unfortunately for them, one of their customers was the wife of a lawyer. Mrs. Carlill purchased the carbolic smoke ball. They advertised it in the newspapers, and they advertised in chemists' windows with a message which basically said that if anyone purchased the carbolic smoke ball and then used it in the appropriate manner, then the makers were so confident that it would ward off the flu and keep you safe that they would pay a reward of £100 to anybody who purchased the smoke ball and was contracted flu within 6 months thereafter. Now, this was not a cheap piece of equipment. Way back in 1890, it cost 10 shillings, which in today's prices would be around 1 week's wages for the average worker. Once you'd used it, you could refill it for 5 shillings. It consisted of a rubber ball with a hollowed out center, into which you poured a very weak form of acid known as carbolic acid. Then you inserted a tube into the acid. The other end of the tube split into 2 parts. And this is very Victorian, you then stuck both of the parts of the other end of the tube up your nose, and you inhaled the fumes 3 times a day. Sounds disgusting. Well, Mrs. Carlill saw this, and she purchased one, and she used it in the appropriate manner for 6 weeks. And you could probably guess what happened. She got the flu. So she demanded her £100 reward from Carbolic Smoke Ball Company, who didn't want to pay. And it ended up with her husband having to sue them. And they defended the claim, basically saying it wasn't a contract, it was a bet. The judges weren't having that. They said it wasn't a contract because they'd never met Mrs. Carlill. So how could they have made an offer to her? Well, the judges said you made an offer to the world at large with your newspaper adverts. They then said, well, Mrs. Carlill never contacted us, so how could she have accepted it? And the judges said she accepted it by her behavior. She purchased a smoke ball and used it in the appropriate manner. That's acceptance by behavior. And in fact, the judges found that a contract did exist between Carlill and the Carbolic Smoke Ball Company, but on a technicality, the technicality being that only somebody really stupid would have believed the statement that £100 reward would be paid. They found a reason not to pay. But the main legal point was proved. Right, let me just have a quick look at some of the questions that are being raised here. No sound. I'm at full volume. I can't understand why you're not hearing me. I'm going to assume some of you can hear me because I haven't had any messages from the people running the presentation, and I can see that my volume appears to be working. Let's move on. Acceptance. Well, the acceptance must be unconditional. Now, a counter-offer, trying to negotiate, that's not acceptance. A counter-offer, unfortunately, kills off the original offer. In Hyde and Wrench, Mr. Hyde wanted to sell his farm. Sorry, Mr. Wrench wanted to sell his farm. Mr. Hyde started arguing about the price. So Mr. Wrench didn't reply. When Mr. Hyde said, all right, I accept the first, Mr. Wrench said, I don't want to sell it to you anymore. And the Court of Appeal agreed with Mr. Wrench way back in 1840. Mr. Hyde's counter-offer had killed off the original offer. Now, there must be a meeting of minds. Well, this is very strange. How can the judge know if my mind has met your mind? Well, the case of Smith and Hughes, again from the 19th century, when all these contract law doctrines were being brought into being by the judges back in the UK and in the Privy Council, they decided, in the case of Smith and Hughes, where Mr. Hughes, a racehorse owner, had looked at the sample provided by Mr. Smith and said, yes, this is the quality I want. And they then described the price, quantity, and delivery dates of the new fresh green oats, which Mr. Smith was going to supply to Mr. Hughes to feed his racehorses. The judges felt that when Mr. Smith was being very hard done by, Smith, the supplier of the oats, had turned up at Mr. Hughes's premises with the first sacks for the delivery, and Mr. Hughes had said, these are not fresh, these are fresh green oats. And Mr. Smith said, yes, exactly the same as the sample. And Mr. Hughes said, you must have known that these are for racehorses. You must have known that I was thinking that only aged oats can be fed to racehorses. You must have known I was thinking that. Mr. Smith said, no, I didn't know anything of the sort. And the judges agreed with Mr. Smith. Mr. Hughes behaved as if he'd entered into a contract, and he'd be treated as such. And this is what we call, in a way, promissory estoppel. If you behave in a way that makes you think you varied the terms of the contract or entered into a contract, then the other party will be protected against you. The leading case on this is a case from the Second World War, Central London Property Trust and High Trees House, whereby the owners of the building agreed to reduce the rent by 50% for the period of the war. Well, in 1945, when it appeared obvious that the Allies were going to win the war, they tried to put the rent up to the full price and also sue for arrears of rent, dating back to 1940, when they reduced the figure. The law lords said, no, this is what's called promissory estoppel. You promised you wouldn't do that, so you're not allowed to do it. Right, let's move on. If you ask for a greater explanation of the terms, that's not a counteroffer. I offer to sell you my car, and you say, how many miles has it driven? Well, that's not a counteroffer. You're just asking for more information. I offer to sell you the car. You say, how big is the engine? That's not a counteroffer. Again, another case, this time from Jamaica, Harvey and Facey, first reported in 1893, decided finally by the Court of Privy Council in the UK, way back at the end of the 19th century. All was happening here was somebody was asking the price. The owner told him the price, but there wasn't an offer to sell. It was just information. And consideration, the thing of value. Consideration must have a value, and there must be something of economic value in it, but it doesn't have to be equal to the value of the thing you receive. We've all, not to say we've all, many people go into antique shops looking for a bargain, hoping to find something that's really valuable, which the shop owner doesn't realize. The shop owner has priced those goods. That's an invitation to treat. An invitation for the customer to pick the item up and go to the shopkeeper and say, I wish to buy this for the price on it, the price displayed on it. The shopkeeper then accepts that offer from the customer. So they go into an antique shop hoping to find a bargain for £5 or $5, hoping to find something that's worth £10,000. Doesn't stop it being a valid contract if the shopkeeper accepts less than the true value. When you walk past a clothes store with a suit in the window which says £5, that's not an offer to sell it to you for £5. That is what is called an invitation to treat. It's an invitation for you to go into the shop and say, to make your offer to the counter assistant to say, I will buy that suit in the window for £5. If the counter assistant then says, oh my goodness, that's a terrible mistake, it should say £50, they're entitled to do so. Because they didn't make an offer, they merely invited you to come in and make an offer to buy it for the price displayed. Now, capacity. The law recognizes any adult legal person or properly formed legal entity as being capable of forming the intention and having the legal right to enter into a contract. But there are restrictions on who may not enter into a contract when you come to human beings. For example, minors, that is, children under the age of 18 or 17 in some countries, may not enter into a contract. They're children, they don't understand the serious nature of the contract. Mental patients at a mental hospital, they can't be allowed to enter into a contract purely to protect them from people taking advantage of them. People who are presently bankrupt can only make contracts for the necessities of life: food, clothing, accommodation. They can't enter into contracts to buy cars or borrow money. And particularly for the British, of course, as we're fighting everybody at some stage, enemy aliens, people who are enemies of a country with which your country is at war, you cannot enter into a contract with them, nor with other companies trading or registered in that country. And the leading case on this is a case dating back to the Crimean War, where a British company wanted to load goods at a port in the hands of the Russians. And serving prisoners in prison can't enter into contracts. Now, the intention to create a contract. Well, you must have a clear intention to create a contract. That is, to be bound by its terms, not just some loose arrangement to work towards the general increase of the market. It's got to be a specific agreement as to what it is you're doing. Some vague arrangement to work towards a common purpose. Sounds like a kind of vague kind of partnership, but it's certainly not a contract. Now, you've got to be certain in the contract who the parties are, what the consideration is, what the main terms are. Only then is it a contract. Even if you write it down and sign it, it won't be a contract if it hasn't got the main terms, the main obligations, the main rights. Because it can't be a contract, you haven't yet reached full agreement. Even if you write things down and sign it. Now, I have to say this about signing contracts. What better evidence could there be that you intended to be bound than writing it down, calling it a contract, and signing it? That's an excellent piece of evidence that this is, in fact, a contract between us. Now, it's understandable that when people are negotiating with 5 or 6 possible suppliers, for example, they don't want to give their final decision until they've received all the information from all the suppliers. And so it's possible to cloak your intention by specifically stating in writing in the document, even if I sign this document, it's not a contract until I say it is. What you are doing there is you are specifically withholding your intention to create a contract. Now, the two leading cases on this are one from Australia in 1954, Masters and Cameron, where Mrs. Cameron was thinking of selling her farm. She signed a document called a contract. She received $20,000 deposit from the other side, but she wrote at the bottom, "This is not to be considered a binding contract until it is approved by my solicitor." Well, that clearly showed she withheld her intention to create a contract. And in very similar terms, earlier in the 20th century, Mr. Crompton, who made that old form of business paper called carbon paper, which you used to put, I'm talking to the older people now, you used to put between 2 sheets of paper in a typewriter, and as the keys hit the top sheet, the carbon paper left an impression on the thin sheet of paper underneath it, so you'd have a copy of whatever it was you typed. Mr. Crompton owned this company, and he had an agreement with his agents in America, Rose and Frank, who came over to discuss next year's supply. They agreed the quantity, the amount to be paid, the delivery dates. They agreed everything. They wrote it all into a document, which they called a contract, and they signed it. But they wrote at the bottom, "This document is not to be considered a contract, nor is it to be enforceable in any court in the US or the UK until it is approved in writing by our solicitor." Again, clearly, it was not a contract. They withheld their intention. The parties must intend to create a contract, not some loose social arrangement. If I say, I'll meet you at the pub tonight for a few glasses of beer, oh, that's lovely. If I don't turn up, you're not going to sue me because it's a loose social arrangement. The parties must be clear about all the terms. There must be what we call the meeting of minds. And because of this, if there was fraud, that is, a deliberate misstatement of the facts with the intention of inducing the other party to enter into the contract so that he would suffer a loss or that I would gain a financial benefit, or mistake by both parties about an important part of the contract, or misrepresentation, a misstatement of the facts, or duress, which is unfair pressure, for example, threats or constant nagging. These can all invalidate a contract because it must be voluntary, where both parties know what they're agreeing to. So entering into contracts is not exactly rocket science, is it? It's all just common sense. Unfortunately, there are lots and lots of different cases and different laws around the world which have complicated it more, but the general principles are the same, whether it's Australia, Canada, India, South Africa, the US, the Kitts and St. Nevis, the British Solomon Islands. It's the same in 1/3 of the world, in all the common law jurisdictions. Well, is there anything else I need to tell you? No, I don't think there is. Those are the general principles of contract law. Now, I've made certain, one other thing about an offer. If I make an offer to you and I change my mind, then the offer stays open until I communicate it to you. If you accept it before I communicate it, then you've accepted it. All right. Now, I've covered every point in the 20 questions which are going to follow in the next exercise. I know that was rather general, but I've only got a limited amount of time. This is one of the 40 lessons from our general contract law course. I hope you enjoyed it. I'm going to pass you back to Abhay. Abhay, thank you very much for giving me this opportunity. I saw lots of messages from people who couldn't hear me, so I'm hoping the vast majority could.
So you were loud and clear, so no problem, sir. So some people might have problems due to internet.
It's been a pleasure to speak with everybody today.
Thank you for the insightful session, sir. Thank you.
I'm going to be running some other training, which I'm going to go back to now, some live training. My first live training for about 4 months because of the COVID-19 situation.
Yes, sir.
I put my mask on before the students come back in the room. Thank you very much, everyone. I hope you enjoyed it. Pleasure.
Thank you, sir.
And Abhay, thank you very much for the opportunity.
Okay, thank you, sir.
Everyone, see you again soon.
See you
Bye-bye.
soon. Bye,
Bye.
sir.